Thank you for coming to everybody who's here in person and online. In particular, I'd like to thank the Law Society for inviting me to speak on this today. It's always a pleasure to address my colleagues on the work I'm doing, and I'd love to hear from you on the work that you're doing. Today's presentation is about homelessness, but it's, as you see on the slide, maybe not so much about homelessness. The homeless are not the other. The homeless are us. They are us, we are them. And my very long introduction this morning is going to be on that first syllable of homelessness, home. Eagles live in nests, rabbits live in warrens, and humans live in homes. Why do humans live in homes? Because humans are vulnerable creatures. We have to sleep for 1/3 of the day. While we're sleeping, that leaves us vulnerable to the elements and to predators, those predators especially being other humans. This is why birds make their nests up high. It's to be away from the snakes that'll eat their eggs. This is why rabbits live underground. It's so that they can be away from the foxes that live on, that can't get access to them. And for me, once I lock my door at night, that is the moment at which I can sleep soundly knowing that I'm safe and secure. Humans acquire possessions. We make space in our home for our possessions, especially food storage. And we dedicate a large amount of our homes to food storage and preparation, as well as collecting the things that make us who we are. Humans, since the beginning of time, have been cleaning themselves. And today, that cleaning function of the human body mostly takes place at home, with running water and with a lock on your bathroom door so you can do so safely. This is at the very core of what home is, and home is so much more in addition to these things. But it's impossible to think about human flourishing without really digging into a consideration of what home is. When I was born, my parents were very excited to take me to one particular place. They were excited to take me home. And if my parents were not able to make a home for me, the government would have taken me, little baby Peter, and put me with some adults who could make a home for me. That's how important home is. Houses, by contrast, are a commodity. Home is not a commodity. But of course, in our society, home is most often made inside the commodity of housing. If you lack the resources to buy or rent, then much like the baby who can't make a home for themselves, the government steps in to provide you with a space where you can make a home for yourself. That's called public housing. Public housing is a social good that ensures that humans remain in their natural state, where they can live with a lock on the door, running water, and all the features of safety and security that's required for human flourishing. But what happens when that safety valve of public housing is inadequate for the human need for housing? By example, right now in Yellowknife, there's approximately 300 to 400 people with no home. They are homeless. There are approximately just under 100 emergency shelter beds. Not homes, mind you, but just beds. Even if the shelters were full today, and they're not, but even if they were full today, that would leave hundreds of humans in Yellowknife with no home. And it's not like there's 200 vacant apartments that are available for rent right now in Yellowknife. There are not even close. So in our city and in most cities in North America, public housing and even shelter space has become scarce. I don't know why that is. I can't provide an explanation for that, but whatever the reason, it's the lack of public housing or housing in general that causes humans to become homeless. As I said at the top, humans live in homes because humans are vulnerable. But if you don't have a home, you're not going to get the required 6 to 8 hours of sleep you need. You don't have a place to store your food. You don't have access to electricity to do things like charge your phone. You don't have running water to drink or to clean yourself with. You don't have a lock on your front door for personal security. You don't have access to things like waste removal. And so what happens for people who are living with homelessness is that it amounts to a constant state of vulnerability. No personal space, People who are homeless are perpetually irritable from lack of sleep. They're exhausted. They're constantly on the move to access things like electricity, toilets, and other basic needs. This is not a situation in which human life can flourish. We call it a humanitarian crisis because to live without a home is to live in inhumane or unhuman conditions. It would be akin to the eagle or other birds making a nest on the ground, where they would be constantly fighting off predators who are going for their eggs, or a rabbit who is constantly on the run from foxes. And the people who find themselves in this situation are a minority of humans. And like most minorities, they face an onslaught of unfair criticism. They're denied basic dignities that are available to other people. They're excluded from spaces like grocery stores, and they are in a constant state of stress and panic and defensiveness. Why are they like that? Because they lack the benefits of home. Homeless people are exhibiting the symptoms of a lack of home. Can the homeless solve their own problem and make a home without buying, renting, or access to public housing? Sometimes, in some ways, yes. They can sleep in stairwells, or in your garage, or in your shed, or even in your car. These are all extremely poor substitutes for home, but they'll do in a pinch. I pause to note that some prefer living in your garage or in a stairwell to living in a shelter, because at least it's a little bit private. They don't have to sleep in a dormitory setting with other people who are likewise irritable, defensive, and unclean. More recently, a small minority of homeless have taken to cooperative living in tent encampments. So this is a minority within a minority who are living in tent encampments. In Yellowknife, we're talking about around 10% of the homeless population live in tent encampments, and that's in the summertime at its peak. I don't have a particular count, but I estimate at most about 30 of the 300 plus homeless people are living in organized tent encampments. These encampments in Yellowknife and in other places have popped up on private property and are inevitably redirected to public lands. When those encampments pop up in public lands like a public park or a recreation trail, they are eventually over time pressured to move to a less inconvenient public land. And encampments on commissioner's land in the NWT or Crown land in other jurisdictions, these pose the fewest barriers to entry, and in the end is a total last resort. I'm sorry that part of the quotation up here is blocked, but it may be too complicated for me to solve that issue on the fly.
So just read us the quote.
I can't even read it.
Oh, sorry.
No, it's okay. At the encampment I represent, there were 5 people who lived there all winter. And during that very cold winter, one of the coldest in the last 10 years, those 5 moved indoors when opportunities arose or necessity made it absolutely inevitable. But those opportunities were few and far between. And this is the first year that I'm aware of that there was ever an organized encampment that persisted through a Yellowknife winter. I think actually the more important quote on the screen here is the one made by one of my clients. You can tell that he put in a bit of hard work and that he took some pride in this. And he says in the end, I don't consider myself homeless anymore. He's got a place. It's tempting to ask you to close your eyes and imagine what it must be like, but I'm not going to ask you to do that because I don't think you can, and certainly I can't. If you haven't experienced homelessness, it is frankly impossible to imagine because it's to imagine insanity. It's to imagine perpetual insecurity. It's to imagine desperation and a degree of uncleanliness that is hazardous to your own health. So I agree that, in fact, I can tell you what it says behind that little thing. It says, encampments are a miserable and desperate place. It's a miserable and desperate place. But even This miserable and desperate place can address the central need of the homeless, which is to feel at home. Shelters don't address that need. Complex standard operating procedures or other things like that don't address that need. The need is to be at home, and only the making and maintenance of home can address that need. And I do want to just dwell on that for one last moment to say that when we're talking about homelessness, the need at the core here is the need for home. That's really what I'm getting at. It's not a legal issue. It's more of a human issue. That's the need for home. So with that rather long introduction, I want to set out my roadmap for where we're heading next. What is it like to represent an encampment? What is the lawyer's role in representing an encampment? How do we do so with cultural competence? Given the many uncertainties of this new area of law, how do we develop best practices? And I'll say at this stage, what I do entirely at this point is public advocacy and a little bit of solicitor work. I'm not litigating this issue. So I will have a few war stories to tell you about that. And the second issue that we'll talk about is what is the law on removing encampments? I have never litigated this. It's never been litigated in the Northwest Territories, and I don't expect that it will be. Maybe it will. I don't think so, though. Though I do want to give a brief shout out to my childhood friend, Joanna Mullen, who just by pure happenstance was counsel for an encampment on the case that we're going to be discussing today. So if you're going to represent homeless encampments, or even if you're representing homeless individuals in other circumstances, some of the things we talk about next will be useful to you. And hopefully we'll be leaving some time for questions at the end. The word that's blocked out there is cultural. This is about cultural competency. Typically, we think about cultural competency as it relates to ethnicity and nationality. In the NWT, we're often speaking about cultural competency about Indigenous peoples, understanding the distinctions between the cultures of the Dene, the Cree, the Métis, the Inuit, and others. But it takes on a similar meaning when you're relating to people of a different social class. Again, I don't have the lived experience of homelessness, so my approach has to take that into account. I don't know what it's like to be them, and trying to understand where they are coming from is a big part of cultural competency. So here are a few helpful guidelines. The first is drop all stereotypes. Okay, this one is a bit obvious. There are 101 reasons why somebody might be homeless. If you assume that your client has a criminal record, or that they're a drug addict, that they're a sex worker, then you're doing your client a disservice. Because just like any other client, you have to hear from them who they are, what their struggles are like, and what brings them into your encampment, or even if they're not living in encampment, what brings them to needing your services. I will say there are two people who live in my encampment who would have been well-known people prior to them becoming homeless. One was actually an MLA for a time. He's living in the encampment. He was there all winter. Another was a community organizer. He's been living in that encampment all winter and through to today. But let's say that your client tells you that they are in fact a drug addict with a criminal record and they engage in sex work or any of the above. This will mean that certain aspects of drug subculture, criminal subculture will be important to them in a way that is either unimportant to me as a middle class guy, or something that I just frankly don't understand and will never be able to wrap my mind around. So one example is one client who lives in the encampment has said to me he'd rather live in a tent encampment than in public housing because he is perpetually concerned that drug dealers are going to take over his unit. This is a phenomenon that's common not just in the Northwest Territories, but everywhere, where drug dealers will essentially abuse an addict by taking over their unit, providing them with drugs for free, and using their kitchen and other spaces to cook crack and then sell it in a larger scale operation. I have a hard time fathoming what that looks like. I've never had that fear in my life. I don't know why the police and the government are powerless to stop it. I don't know. But in order to serve my client, I have to understand that dynamic of drug culture, and it requires my attention, it requires my understanding, and what it does not require is my judgmentalism at all. The rule of thumb here is if it's high on your client's priority list, it should be informing your legal strategy. And so that anecdote in particular, how does that inform my legal strategy? Well, it adds one word to my advocacy. Instead of demanding that my clients be housed, the demand is that my clients be adequately housed. They be housed in a place that is adequate to meet their need for home. Home. The United Nations definition of adequate housing includes things like security of tenure. And if drug dealers are taking over your unit, you do not have security of tenure. The work of the lawyer is often in many areas of law to reframe concerns in the language of the law. You can only do that if you practice law without stereotyping your clients. Otherwise, there's going to be many things that are lost in that translation. Navigating communication hurdles is another big one. Your clients will not always have working cell phones. Sometimes they will, and sometimes they won't. Your clients will not often be keeping calendars for appointments, court dates, or other important things. That will affect your ability to communicate with them. Your clients may or may not have email that they can access at the library sometimes when they feel like it. You have to get used to meeting in person, and that often looks like me dropping in on them at the encampment or them dropping in on me at my office. We're not scheduling appointments, we're just showing up. And unfortunately, or fortunately, this is the normal way that this practice works, even if any other practice area would consider that to be abnormal. I saw a lot of criminal practitioners nodding along, by the way, like, yeah, we've all experienced this. The last point here is you have to develop some form of class consciousness. I'm not suggesting that you have to be a Marxist or contemplate, the material dialectic. That's not what I mean. What I mean simply is that you have to consider that our society has some form of a class system and that you are in a different class than your client. Even if you are poorer than other lawyers, by virtue of your legal education alone, that puts you in a higher class. And I don't mean to be critical of our society too much here. We do live in Canada where you can transcend class. It's possible. In other societies in history and in the present, that was never possible. But in our society, you can transcend class. So I don't want to say that the class structure is fixed. But at a point in time when your client is in the encampment and you're living in your own home or even renting, you're in a different class. I have to acknowledge to myself privately, and now I will do so publicly, that despite the fact that I walk into their encampment, into their home, into their space, they are never welcome in my home. Never. I'm embarrassed to say it, but this is the thing about class. My landlord in the apartment building I live in would probably raise the concern with me if I invited clients over for dinner. He'd say, well, other tenants are concerned about having homeless people around. I think it's important to pause to acknowledge that as far as solicitor-client relationships go, this is essentially how it was for Black Americans and some Black Canadians during segregation. It wasn't just that Black families couldn't live in your building. They couldn't even come over for a visit with a white family in certain parts of the United States. It would have been scandalous. And in a similar way, not in the exact same way, but in a similar way, it would be scandalous to have homeless people over to our homes on a regular basis. Here's a bit of a war story that relates to this. After one particular victory that we had with some of our advocacy, I encouraged a couple of my encampment resident clients to go out for lunch, like, let's celebrate, And I said, any place you want, we'll go. And they looked at me like I had 10 heads. And I was like, and saying, can't we get takeout? It didn't occur to me until I got home later that day that these people aren't welcome in any restaurants in town. And even if they were, even if it was like, a progressive, cool place like Birchwood or something like that, we could go in, but it would be a remarkable moment for the other people who are eating there to see homeless people dining with them. And it might even be remarkable for the staff. It would certainly be remarkable for my clients who don't usually get to experience that kind of casual interaction in a business. That's a class distinction. The second war story here is there was an encampment member hanging out outside of the Shoppers Drug Mart one day, and I had just left court, so I'm wearing my suit and tie. I was walking up the street with nobody less than the chief federal prosecutor when this person approached me and said, "Hey, can you grab me something from inside Shoppers?" And I said, "Yeah, of course, no problem." So I walk inside, I grab what I was going to grab for myself. I grabbed this Pepsi for my client. And as I was exiting the Shoppers Drug Mart, he was kind of in that little exit vestibule there right by the end. And I meet up with him, I hand him the Pepsi, and we walk out. And just as we're walking out, a security guard comes into our face and just starts yelling at him, "Hey, you know you're not allowed to be here. You can't be here. Get out of here. I've told you 100 times." And I was like, hello, like he's in the company of a guy in a suit and tie. Is this really appropriate? And when I looked at the security guard, I said, "Okay, we heard you. That's enough." He then started yelling at me. I guess the point of the story here is I don't know what it's like to be hungry or thirsty and to know that there is a security guard protecting the food from being eaten by me. I don't know what that's like. So the tools of cultural competency are here to help you understand and develop that kind of consciousness. And without considering these questions, I don't think you can really be an effective advocate for the homeless. This is the type of life they live. It's different than the type of life that I live. What's missing on the screen here is flexibility in expectations and outcomes. And that first slide that's a little bit obscured there at the top is the encampment is not your home, so don't rearrange the furniture, okay? You can advise your clients to keep the space clean. Believe me, I have. But if they don't do that, you must let them do that. I advise them all the time, and you may advise them to not use wood or any flammable materials in constructing their ramshackle tents. But if they do use wood or other flammable materials, you have to live with that. Everybody in this room knows that it's often the case that our clients don't take our advice, okay? But the difference when it comes to homeless people is that we're far more inclined to be paternalistic with the homeless than we are with other clients. Do not be paternalistic with your homeless clients. In an encampment setting, it's not your home. You're not the warden of the encampment. You're not the landlord of the encampment. You are the advocate for the people who live there, and that is all. Don't tell them how to live their lives. Or, you know, maybe when they raise it with you and say, "Oh, I really got to quit the drugs," you can say, "Yeah, you probably should." But you don't kind of start those conversations and make it a paternalistic relationship. The encampment must be temporary, and therefore your role is also temporary. Your role is not to make sure that the encampment exists in perpetuity, okay? If you represent an oil company, you're probably hoping that they don't go bankrupt, unless you also practice bankruptcy and insolvency. That was a joke, you can laugh, it's all right. But if you represent an encampment, you have to hope and expect that these people will live in homes or live somewhere other than the encampment at some point, okay? And so your role as encampment lawyer is going to end. What you want is to resolve the issues of the encampment in favor of your clients. That's the goal. You want to resolve the issues of the encampments in favor of your clients. You'll hear me in the media all the time saying, "I don't think encampments should exist. They're a stain on our society." I believe that in my heart. But what you want is when this encampment does come to an end, that it comes to an end where the rights and the dignity of your clients have been preserved, where some of the outcomes, they were able to participate in obtaining those outcomes, and that those outcomes suit their needs. So as I identified at length at the outset, the need is the need for home, not the need for a shelter, not the need for a place to stay at night. The need is a need for home. And so for my clients, that means getting adequately housed, not in a shelter and not in a new ghetto encampment in a different public park. The need and the goal is to get homed with real housing, with security of tenure and all the other accoutrements of home. I'm going to be just a little bit self-indulgent for a moment and say that the role of the encampment lawyer also takes a toll on you as an encampment lawyer. You're doing work in the public. I'm aware that I'm something of a novelty, even amongst other lawyers, and you know, lawyers are usually attracted to money like moths to a flame. There's no money here, right? But you have to get used to the idea that everybody's going to have an opinion about you. That is genuinely how I see myself sometimes, just exasperated at the end of the day, wondering how much more free work I can do. I'm grateful to my friends who think that I'm some sort of, hero. I'm not. That's not what we're doing here. My poor parents were hoping that, you know, I was gonna be owning a home by now, 10 years into my career, and I shouldn't be too hard on them. They're not judgmental of me. They support the work, but you know, these are things that you have to navigate. And then, of course, if you don't recognize crazy old Maurice from Beauty and the Beast there, sometimes the public is going to just think of you that way, that you're just some guy shaking your fist at the world and saying, you know, how come this inequality persists? It does take a toll on you to have all of these disparate opinions of you just being out there. Let's talk a bit about who the client is. In any kind of group setting, sometimes you do need to identify who the client is so you know who you're taking instructions from. There is no perfect answer to this question, but I've determined that at least in my encampment, we've been working on what Major League Baseball calls the next person up approach, okay? So natural leaders emerge. And when the natural leader is unavailable, then you go to the next person up. So we've had situations in our encampment where somebody was actually got into housing. So they left the encampment, they moved into their new home, and a new leader emerged. We've also had situations where the leader gets arrested. And now they're spending a little bit of time in jail, and a new natural leader will emerge. From my perspective, you must let the encampment select its leaders naturally. Even if you would prefer to be liaising with a different person, there is a major benefit to liaising with the person who emerges as a natural leader because it avoids factionalism developing. And if factions do develop, the best I can say is resolve those factional disputes quickly. At the heart of this is trust. Trust is the essence in every solicitor-client relationship, and you develop that trust through cultural competency, through sharing updates with your clients in writing when possible. You develop trust by getting results or candidly explaining why those results are out of reach right now. I've put on the screen as well, define your role as being limited in scope. So whenever you're dealing with people in the encampment, let them know that I can help you advocate in the public, but I'm not going to be able to help you with your other legal problems, right? One guy in the encampment, his girlfriend had her car impounded, and he was saying to me, well, can you help get the car back? It's a really big deal to us. And I was like, that's way outside the scope of what I do. I wish I could help you, but I can't. Is there a perfect approach? No, but in a fluid situation like this, where people are in and out of the encampment, you have to do your best to ensure that you're acting on behalf of the client and not some designer client that exists only in your mind. The part of the screen that's covered up there is that if you're not taking instructions from a client and you're just doing what you want to do, that's very bad. Don't do that. If you find yourself that you're gravitating towards a sort of mediator or ambassador role between government and the homeless encampment, don't do that. That's also very bad. You're an advocate for the encampment. You're not a mediator between one class and the other. So in summary on this portion of the talk, cultural competency is indispensable. Know your role, stay within that role, and identify from whom you are taking instructions. So now let's talk a little bit about what we all came here to hear about, law, right? The one case I'm going to be focusing on in particular is the region of Waterloo versus the named persons and persons unknown. The reason I picked this case is because it's the most recent. It came out, I want to say 3 or 4 weeks ago. And it is the only case to find a breach of Section 15 of the Charter. That's what's covered up on the screen here is Section 7 and Section 15. There's a lot of other cool stuff in there too. If you're interested, you can take notes on that and pop over to the Canley and read it. There are no judgments from any courts of appeal yet that I'm aware of. However, Ontario has a case before the Court of Appeal that was argued, I think, in February. We just don't have a judgment yet. When it's released, maybe some of the things I'm telling you here are going to be moot, but what I want to give you today is just some insight into the current judicial discourse on removing encampments. And as I've mentioned, I've never litigated this, so apologies. This is going to be more of a book report than it is about personal experience having done this. Just kidding. Typically, the litigation is initiated by the government in order to obtain a declaration in advance of removing an encampment. The declaration is to say that both the bylaw that they're enforcing is constitutional and the act of removal is constitutional. In the past, both in all over North America, but including in Canada, governments have sent in the police clear the encampment, people are injured, they sue, the public has an outcry. This should be avoided at all costs, of course. And it's never happened here in the Northwest Territories, as far as I know. But now, in the past, I want to say 7 or 8 years in particular, governments have started applying to courts to get this type of a declaration so that they can, with confidence, remove people. The legal issue is always whether the bylaw that prohibits camping on public lands is constitutional. These bylaws typically look like summary offenses where if you're caught doing this, you can be arrested without a warrant. There's usually no jail time associated with the offense. It's fines up to $5,000. That's what it was in the Waterloo case in any event. In the Waterloo case, the defendants, the encampment, also cross-applied to seek a declaration that the bylaw authorizing removal was or the bylaw against camping was unconstitutional. So again, the remedy formally is a declaration, but in practice, that means the encampment gets to stay. I'll just highlight a couple of the arguments made, and they're on the slide here. One of the arguments made on Section 7 about life, liberty, and security of the person was that removing people could increase the risk of hypothermia, heat stroke, dehydration, and fatigue. It's interesting to note that in Yellowknife in -40, hypothermia is the least of your problems. And of course, from February to July, in those 6 months, you're going from the risk of hypothermia and freezing to death to smoke inhalation while you're outdoors the entire time. A client who, in my encampment, had a ramshackle system with a wood stove around his tent. And one night he had burned himself on the stove. He didn't think the burn was that bad. But a couple days later, he realized he needed to go to the hospital. Turns out that he had, and I don't want to get this wrong, but I think it's encephalitis, which is like the sort of precursor to a more intense flesh-eating disease. Luckily, they were able to treat it. They didn't have to remove the arm. But these are the types of dangers that emerge when you're living in these type of situations. The Section 15 argument includes the fact that a substantial portion of the people in the encampment in Waterloo were Indigenous. And again, I've highlighted the numbers on the screen, 17% in Waterloo. 1.7% of the population of that region was Indigenous, 17% of the homeless were Indigenous. I don't have a number for the NWT, but I think the best estimates are that it's at or just over 80% of homeless individuals are Indigenous. But again, the part that's a little bit blocked on the screen here is that the bylaw was about camping on public lands, and the government needed that land for a transit expansion. If you follow Ontario news, it's a Metrolinx expansion to create more public transit. Oh, okay. This one I definitely have to take a moment to try and move the slide here.
Chuck said that if you were to do that, you might drop the ball. So just be careful.
Oh. Ryland, are you still there? Okay, I'm gonna assume that it's fine. You guys know about Section 7 of the Charter, right? The factual standard here is, I'll just read it to you from my notes. The government must prove that the number of shelter beds exceeds the number of homeless in that region. This has been the most common articulation of the test, though it varies from province to province and from case to case. There had been at some point a case that said, well, during the day, camping should be banned, but at night, you should be able to set up a tent and sleep there. It's a bit of an unworkable standard, but you know, courts are trying their best to address this novel issue. But this is the most common articulation of the test. It's the number of shelter beds versus the number of homeless. And if the number of shelter beds is adequate, or if it's high enough, then we're getting rid of encampments. But if the number of homeless is greater, encampments can't be removed, and the bylaws in that sense are unconstitutional. In this case, and in some other cases, the courts have left it open for the government to come back to the court once the numbers have shifted so that they can lift the declaration of unconstitutionality. Is this standard about housing, or is it about home as we defined home at the outset? The standard is about shelter space, but in a sneaky way, it's about home. Let's just talk about the numbers first before I circle back to that. The court notes that there are 377 shelter beds for roughly 2,400 people who are homeless. And about 1,000 of them in the region of Waterloo were sleeping rough, as they say, sleeping outside. There were only 20 people in the encampment. So a very small minority of the homeless were in the encampment. In Yellowknife, by comparison, again, the shelter beds are about just under 100, roughly 300 to 400 homeless. It's not clear how many of them are sleeping rough. I don't have that number. But presently, only 15 people or so in the encampment I represent, and maybe at its peak, in the peak of summertime, 30 people in organized group encampments in the summertime. So the question arises, what if there are 15 available beds and 20 people in the biggest encampment, and the small encampments, you know, maybe have less than 15 people? Would we tear down the small encampments and force those people into the shelter and let the big ones exist? No, that's an obviously odious outcome. And what the Judge Gibson in the region of Waterloo case said is, we don't want to privilege some tent encampment users over others. So the number has to do with the totals, not with the people who are the number of people in the encampment. And I think in some way, this is a sneaky way about addressing the question of home. The judge doesn't want to have forced evictions for the people who have made home in a tent where there's only one or two of them tenting together versus evicting people who are living in a much bigger encampment. They don't want to privilege certain encampment residents above others. In that way, I think it is a sneaky way about talking about home. On the more bread and butter side of this, the right to life is engaged because preventing people from sheltering on public lands in the absence of public shelters significantly increases the risk of death, as I described to you a moment ago, or serious injury. The right to liberty is engaged when the state interferes with an inherently private choice. This is an interesting one. If people can be arrested without a warrant for setting up a tent on public lands, then their rights are infringed in that way, their right to liberty. In a sense, these people are trying to solve their own problem, and that is what the court said is critical to any individual's dignity and independence, try and solve their own problems. The right to security of the person is engaged when physical or psychological integrity is affected by government action or law, and obviously that's engaged in the context of a forced eviction, even if it's a forced eviction from a tent contrary to a bylaw. So when we talk about the, you know, the exception here, except in accordance with the principles of fundamental justice, that's where the court kind of stakes its claim on the concept of the availability of shelter beds versus the number of homeless. It would be removal of these encampments would be concordant with the principles of fundamental justice if other space existed. But if there is no other space, then that's a deprivation without outside the bounds of the principles of fundamental justice. Court found a deprivation of all three, and of course, it was not saved by Section 1. Constitutional lawyers might know better than me, but I'm not aware of any cases in which there's a violation of Section 7 that then is saved by Section 1. That trend remains here. So now the real interesting stuff. Section 15. This is novel, this is new, and it's on the back of another novel and new interpretation of Section 15. That case is Quebec and Canada. New case from the Supreme Court of Canada from earlier this year. It heavily influenced the outcome in this case. Kanyinda was about the exclusion of refugee claimants from eligibility for subsidized daycare. Okay. The majority found that it discriminated against women refugee claimants based on sex. Now, this is very interesting because I don't think this has really come up a lot in the section 15 jurisprudence. Chief Justice Wagner highlighted intersectionality. Okay, it's a word that we may know from critical theory. In this context, it refers to intersecting identities that create subsets of people within a larger group. So, for example, by denying refugee claimants from eligibility to subsidized daycare, that doesn't discriminate against all women, but it discriminates against a subset of women. And that is, as far as the Supreme Court was concerned in that case, it wasn't discrimination against the entire group, but just enough discrimination against a subset of that group to breach Section 15. So the court here on this encampment case said, the question is whether the bylaws disproportionately impact those homeless who are women, disproportionately impact those homeless who are gender diverse, those homeless who are disabled, those homeless who are Indigenous. And the judge said, when taken cumulatively, homelessness itself ought to be considered an analogous ground. That is brand new. That is what many advocates for the homeless, like Martha Jackman, who was on this case, have been asking for decades. It is a big deal. Rather than, well, you know what, I will. We've got a little bit of time. I do want to say that I'm going to be reading a little bit from the case here, which is, you know, not always the best thing to do in a presentation, but I think it's important to hear it. First, a distinction based on homeless status may violate the dignity of members of the group because the status is apt to give rise to stereotypical reasoning. Judging a person on the basis of this status, rather than according to the merit or their attributes, could well negate a person's dignity and worth. Second, homelessness is a constructively immutable characteristic because it is not a situation that is within the individual's control. It is not readily alterable by conscious action by the individual. And in this way, it's a little bit similar to religion, right? Religion is not necessarily an immutable characteristic. You can change your religion, but common sense kind of tells us that that is a major shift in who you are, in your dignity. And so in that case, in that situation, it's constructively immutable. The court goes on to say, as the ancient folk aphorism succinctly observes, if wishes were horses, beggars would ride. The transitory nature of homelessness does not prevent this status from being considered an immutable characteristic. It is one of those characteristics that, while they last, are considered beyond the individual's conscious control. Third, and this one is extremely important, homeless are a historically disadvantaged group in addition to being a discrete and insular minority. The important part is this: they lack political power, which makes them vulnerable to having their interests overlooked and their rights to equal concern and respect violated. I was on CBC 2 days ago complaining about the fact that I had asked the government, Housing NWT in particular, for my clients to participate in the development of their standard operating procedure. And I was complaining because we were denied that access. So the homeless are a group that lack political power. Homelessness among Indigenous people. This is going to be relevant for the Northwest Territories. The court said homelessness amongst Indigenous people is not simply a matter of individual misfortune. We know this. For Indigenous people, it is well established that homelessness is a consequence of colonization, which dispossessed Indigenous people of their land and resources, propelling and inflicting generations of systemic racism and ongoing trauma. Indigenous people in Canada are disproportionately underhoused, unhoused, and experience barriers to access affordable, permanent, stable, and supportive housing. And it cites the statistics in Waterloo region, 1.7% of the total population identifies Indigenous, 17% of the surveyed unhoused people in the 2024 point in time calculation were Indigenous. As I said earlier, in the Northwest Territories, that number is much higher than 17%. And while I can't predict the future, I would say that if this unless this is overturned on appeal, this section 15 issue, that would be a very difficult hurdle for the government to overcome if they were to litigate removal here. Section 1, very briefly, in a word, overbroad. All of the arguments on this point failed. I didn't want to spend too much time on section 1, but briefly, it's not like the government had been saying in that case, well, we just don't want them on this land. We don't want them on any land, is what they were saying. And the court said the extremity of this position is what ultimately drives the findings that the infringements are not saved by section 1. And that's where we get that other quote again that was covered up earlier. No one should romanticize or be starry-eyed about the encampment. It is a miserable and desperate place, but it represents the only remaining safety valve. Very briefly, in town here, the city of Yellowknife had proposed and had contemplated a ban on camping on municipal lands. That may survive section 1 because municipal lands make up such a small part of the available public land in the Northwest Territories. And insofar as that, people can still camp on commissioner's land. But there are government lawyers here, so I don't want to say too much, but I would imagine that if there was a ban on all commissioners' land, or even all commissioners' land within the city limits of Yellowknife, that would fall into the same problem as the region of Waterloo. It's too broad, it's not narrowly tailored, and the consequences would be creating ghettos on the outskirts of town. So, where are we at here? A law that prevents the homeless from avoiding a serious risk of injury or death by erecting shelter overnight where there is nowhere else to go is a law that has lost sight of its purpose. What is the purpose? What is the outcome that we want? What is the outcome that is best for the people who are living in encampments? Can these things be reconciled with each other? I think ultimately, at the end of the day, the purpose has to be about making a home for people who do not have homes. Although that's not the legal test, that is the solution to the need that is being expressed by people who live in encampments. Home is the purpose. Home is the remedy to the social ill of encampments. If people live in homes, they can't complain about the shelter system being inadequate or inaccessible. Home is what is required to remedy the social ill, and is required so that homelessness, the people who experience homelessness, can flourish inside a home. So I want to thank you again for having me to do this talk, and we do have a fair amount of time for questions, so I'm happy to hear from anybody in the room or online. Paul.
Great question about the case itself. So I understand that the law was overbroad and talked about proportionality, but was the actual intention of that particular law, was it to depict the people that had set up the encampments?
It was a law of more general application. The tenting bylaw is essentially prohibits even people like me from going camping on a land like that. So it's not specifically targeting the homeless. There was quite a bit of discussion in the case about how the bylaw had been amended at certain times and redirected. So it was like, it's a little bit too in the weeds to get into here, but there were attempts made to try and reform it so that it would be a little bit more constitutional. But in the end, the court said it wasn't.
Thanks for that.
Blair.
Are there examples in Canada of jurisdictions or cities that have tried to direct sort of where people camp? So encampments can fall anywhere, but are there examples of places where they don't try to prohibit it, but they try to say it can be done here?
Mm-hmm.
And even setting up facilities, say,
Mhm.
for like waste disposal, that type of thing.
Yeah.
What are the pros and cons of that? Would it just be setting up an outside shelter if, say, the government was involved in that way?
Mhm.
Just make your thoughts.
Sure. Well, one of the examples of a place where that's happened is Yellowknife. Originally, last summer in May, you'll recall an encampment had been set up behind the liquor store. It was actually in a parking lot that was used by various government offices that are down there. And it was in fact commissioner's land. But once I had been on board and been retained, the first thing that I did was negotiate with the government to say, can we go somewhere else that's going to be less inconvenient? Because obviously being behind the liquor store is like amongst the worst places that an encampment could be. And so in working with Housing NWT and Executive and Indigenous Affairs, we said that the land around the museum and by the ledge is appropriate. And so that's when my clients moved from behind the liquor store to the spot where they currently are. I'm being told, no, there are still other encampments.
Well,
There's,
there's a lot going on
Yeah.
there. And yesterday, in case
Yeah.
anybody lost a bike, a whole bunch of bikes just showed up in that one.
thank you, Lydia. I will say I'm not retained by those people who are still behind the liquor store there. Those are not my clients. I actually do not know who they are. When I lost my bike, I went down there to look. And
A lot of bikes.
yeah. Those people are not my clients. So in that sense, we did move and people still use that space because they know it's commissioner's land. The government has not, however, set up porta potties or things like that. I think I understand why. They don't want it to turn into an attractive nuisance where people are now going to live there in a more permanent way. I appreciate that, but we had a city councilor a couple of weeks ago complaining about how their city has become full of garbage. And I've got letters going back to last year saying, can you please get us a garbage bin and waste disposal, right? So there's a bit of a disconnect on some of these things, and that's okay. I will note that in the region of Waterloo case, for those 20 people who were in that encampment, the government had paid for porta potties, garbage disposal, potable water, and other things like that to be accessible to that encampment. And that was while they were actively trying to litigate to remove that encampment. Other examples of this, in Toronto, for example, there had been an encampment in Dufferin Grove. And I always get this one confused whether it was Dufferin Grove or Parkdale, but one or the other, there were a large number of people living there, I think closer to 80. And what the city did is they said, we're going to get hotel rooms for all of you, just so that you'll leave Dufferin Grove or Parkdale in these places that are like basically in the middle of a residential neighborhood, right? Like they were like, we need to end this really quickly. So they bought up a whole bunch of hotel rooms and said, everybody who wants a hotel room can have one. Of the 80 people in that encampment, only 8 rejected the hotel rooms. And by the time the other 72 people left, the 8 were essentially like, well, we can't stay here, let's just scatter. And then the cleanup crews came in to clean up the encampment. So there are some creative ways that have been attempted where people aren't forced out with nowhere to go, where people's dignity and needs are being taken care of. But again, this is kind of a new thing and people our governments are experimenting with how to deal with this. It can be complex. Yeah.
I'm interested to know a little more about kind of the practicalities of the solicitor-client relationship in this context.
Yeah.
So, in particular, a couple of things. One would be defining the scope of the retainer.
Mhm,
And so you discussed, an instance where, okay, that's way outside of the scope of the retainer.
mhm.
Do you have an express scope of the retainer insofar as, ordinarily that might be in a retainer agreement, let's say?
Right.
And then maybe the second question would be defining the client. And you said, people come and go and you don't want to be a mediator, et cetera, et cetera. You don't represent one encampment, but you do another.
Mhm.
So do you have a definition of who is the client, whether that be continuously present in a defined geographic area? Or
Right. Yeah. So the first question about scope, the scope is essentially negotiating with the government and public advocacy in the media and in other places like that. I will not be litigating if the government brings something, I'm gonna have to find somebody else to come in and defend the encampment in litigation. That would be way too much work for me as a sole practitioner to do. And the other thing I've said to them is I can do some fundraising on your behalf, but in order to do that, I'm gonna have to retain somebody externally to do that, right? So how we find the money to do these things is complex, but it's part of the sort of public advocacy, right? For example, I've been soliciting private donations for that porta potty that is there, right? Part of the public advocacy of that was to say to the government, look, we've got one. Can't you pay for it? And I can stand up in the media and say, look, the government doesn't want to pay for this, right? So that's part of the public advocacy and it includes a little bit of fundraising. But yeah, that's the scope. And I'm not trying to solve other legal issues. If somebody gets arrested there, I'm not doing their bail hearing, right? Even though I'm a criminal defense lawyer and it's fully within my capacity, we're not doing that. And so that is something I discuss with people who live there, the natural leaders that emerge, and I try to just keep them on message on that. If they decide to shift that narrative and I feel that it goes outside the scope of what I'm capable of doing, then I just have to have an honest conversation about that. But we haven't gotten to a situation where my ability to act for them and their needs have come into conflict. So that's been frankly a very happy positive. I wasn't sure if that was going to be the case. The second question was about excuse me, well, I paused to think about the second question. The second question was about who is the client, and is it every homeless person or is it just my encampment? I consider it geographically to be the people who live in that one spot adjacent to the museum. I represent that encampment. I've been approached by other encampments, including the one behind the Norseman Apartments building between Norseman and Anderson Thompson. I've said no to representing them because I live too close nearby. It seems a little bit uncomfortable for me to do that. So the advocacy is really for the one encampment, but some of the solutions that I'm proposing or some of the things that I'm advocating for do apply to all encampments in the Northwest Territories. And so I think in some responses I received from the government when I said, I want you to pay for this porta potty, the response was, well, look, we're the government for the whole Northwest Territories. We can't just pay for one porta potty. We'd have to pay for all porta potties.
Great.
And that's exactly it, Lydia. Yes, I'm saying great. Yes, please. Because we don't want people taking a crap in where we're taking a jog or walking our dogs, right? So if we can have those types of things available to all homeless encampments, it solves the problem, not just for my clients, but for the people who live in the city, as well as every other encampment. So I think to the heart of your question, the client is that one group, but some of the things that I'm advocating for would have benefits and uphold the dignity and rights of people who are at different encampments. Does that kind of get to it?
Yeah, I can see that it's not as precisely defined as, say, in other contexts, where say you could have a group, but it would be officers, say, of a corporation or a society who can readily identify as being an instructed client for that purpose. So geographic area, but must they be continuously resident there, for example, to be within the scope of who's your client for that purpose?
And the answer is no, because ultimately I don't want them to be a continuous resident. I want the people who live in that encampment to not live in that encampment any longer, right? So it's a little bit different than representing a corporation in that sense. It's almost like representing a corporation that you want to dissolve, right? You want there slowly to leak out one employee after another, right? So it's unusual in that sense, but the consistency is the location and the consistency is the advocacy for that specific location and the people who are there. I would say there is a core group of about 5 or 6 who are there, like especially the 5 who are there all winter. That core group and I have gotten to know each other very well. There are a few people who come in and style themselves as being leaders, although they're not there very often. Lydia's smiling, she knows who I'm talking about. There are others who come in and out because maybe they actually have more resources to get access to housing indoors at various times than the people who are there all year long. Academics will distinguish, for example, between people who are chronically homeless, people who are on the margins of being homeless, and people who are precariously housed. So people who are mostly housed, but sometimes they're homeless. I have to think of it a little bit differently. I have to think of it as whoever lives here is part of the group that I'm advocating for, and their natural leaders are the ones who I'll take instructions from while taking into consideration the needs of the whole group. Yeah. Lydia.
Peter, can I just make 2 comments?
Of course.
Um,
That's why I invited you.
so just to put some context to all of this. In 2009, I opened the first day shelter in Yellowknife and ran that for 5 years. At that time, we had identified 375 individuals who identified as homeless, and 70 to 80 of them came to see us every day. So when those agencies out there are alarming us by saying the number is increasing, no, we had 375 homeless people in Yellowknife 20 years ago. And 20 years ago, we had a lot of those individuals sleeping rough in tents. Just not, what's new is urban encampments. We've always had encampments. There was one back in 2008. There was 40 living together in the bush behind the Explorer Hotel, behind Chateau Nova, beside that trail to Niven Trail. There was 40 of them. I was invited to stay with them. So, we've always had people sleeping rough. It's only in the recent years that we've had urban encampments.
And, I mean, thank you for sharing that. You've got more experience in the homeless sector than anybody I've found. Well, pretty close to. There also have been people for, probably since Yellowknife was founded, who are sleeping in tents on their own. Without any organization, people who want to be left alone, people who just want a place to stay. And going back to the point about, well, what are your clients' needs? I have with every single leader that has emerged, I've said, look, by doing this kind of advocacy for you, I'm going to draw attention to you. Do you want that kind of attention? Do you want the media coming down here to speak with you? Or would you rather just be left alone? Because I can see why some might just say, look, I'm not trying to be a political actor here. I'm not trying to get change. But the people in my encampment have asked me to do that. And I've tried to say to them over and over again, look, there are ways we can do this quietly. There are ways we can do this openly. What do you want? And they say, do it openly. We want to draw attention to the fact that this is happening. There are many other homeless people who just want to be homeless and just want to be off the radar. Every society from the earliest times has had those vagabonds who just don't feel like they fit in and don't want to fit in. And I applaud those people. I like those people, but those are not the people who are living in my encampment. But the people in my encampment have asked me specifically to engage in this kind of advocacy. So that goes back to your question again about how do you define the scope of these things? Yeah.
Well, as advocates, we have to be mindful of the difference between exploiting and empowering.
100%. Yeah, it's not about me, and that's why I put that in that slide. It's not about me. It can never be about me. And maybe this is an appropriate time to say I swear I will never run for city council. This is not a platform for me to jump into GNWT. It's not about me. It's not about that. It's just about pro bono work for a client that can't pay. Online, are there any questions? Sorry, Blair. It's quiet online. So Blair, you had another question.
The focus on the office encampments here in Yellowknife and beds that are available. And then just the lack of the level of apartments perhaps that are available to people at homes. And this is a question for Lydia as well. What sort of percentage of 300 to 400 homeless people are from outside of Yellowknife, who come in from Eastern Arctic and from parts of the territories? And Brent, do you have any comments on that and sort of reasons for them coming here from those communities and reasons why they or don't feel comfortable going back or are prevented from going back? Is that also a factor?
I'll pass the floor to Lydia first, and then I'll give the more legal context to it, but go ahead, Lydia.
Yeah, 75% are from outside of Yellowknife. And the biggest group is from Beshico. I think Inuvik used to be pretty high, but they're getting more and more shelters in Inuvik now. And so the reasons that they're here, contrary to popular belief that the jail releases them here, that's not true.
It's not true. Yeah.
People have the choice where they want to be. And some people, if we're talking about the correctional system, some people feel too much shame to go back home. And some people don't want to go back home where they were abused. So there are certainly some who make a choice. Some get stuck here on medical travel because if you miss your flight, you're out of luck. So they get stuck. And they no longer have a space in the boarding homes. Some people met somebody and they're here because of a relationship, people from two different communities. There's a lack of support, there's a lack of services and supports and housing in the communities. The jail doesn't release people here, but the bail system does. So, if there's been intimate partner violence in the communities, the release plan is to Yellowknife. There's more men released to stay at the Salvation Army than they have beds. And then once they're on the streets, they hook up with each other and support one another and they find their crew.
One group that Lydia didn't mention is people who have children in foster care and their foster placement is in Yellowknife outside of where their home community is, and they want to have visitations with their kids, so they're willing to live on the street. Even if they had a place to live back home, they're willing to live on the street so that they can have regular visits with their kids. From a legal perspective, I have not been able to wrap my mind around how a court would treat the NWT. Would it treat it as one jurisdiction, which accounts for what you've identified, which is people are coming to Yellowknife from other places, or would they treat Yellowknife as distinct? So would the point in time calculation that they use be all of the homelessness for the entire single jurisdiction that we are, or would they just use the within Yellowknife count? Because there are shelters too in other communities, right? So we may have a situation where the shelter in Hay River, which I think is almost always full, but if they had a lot of space, or if the shelter in Inuvik had a lot of space, but there weren't that many homeless people physically there, would those numbers be used against the numbers in Yellowknife, where the population of homelessness exceeds the shelter number? I don't know exactly how a court would calculate that, and it remains to be seen exactly what approach they would take. But given the concerns you've raised, it seems like taking a big picture approach would be helpful. It just skews the ability to have numbers line up exactly.
It's interesting you mentioned Bechoco because I was in Bechoco last year and the shelter space there was about the size of this room.
Yeah.
Shuttered, so.
Yeah.
Well, and earlier you used the word beds in shelters. In the Salvation Army, it's mats on the floor in a room that 10 mats fill the floor. And you literally step on each other trying to get in and out.
You can see why somebody would prefer to sleep in a stairwell or in a garage than rather sleep on a mat on a floor next to two other dirty guys.
It's really stinky in there.
Yeah. Oh, yeah. Yeah. It is after 1 o'clock, so you're all here in detention overtime. So if you do need to leave, go ahead, but I'll stick around and I'll chat with whoever. I'm here for a while. Thank you, everyone.